Good morning, everybody. Here comes the singing news. Hinkle's gonna sing and take away the blues. All right, welcome. We are glad you're here this morning. There's Glenn's good-looking brother today. I'm glad there's a good-looking Buffington here today, I tell you. I was just reading an old babbler and the Lipscomb paper, and they were talking about the gymnastics team. And maybe you didn't know that Glenn was on the gymnastics team at Lipscomb University back when it was a college. And then I saw that Larry Snow was also on one of the ministers at Walnut Street was on the gymnastics team. Did you know that? You couldn't believe it now looking at Larry, but you can still believe it looking at Glenn. But I came across this little thing about retirement this week. This is a retired health message for all of you. Guy says, I was lying in bed pondering the problems of the world, and I rapidly realized that I don't give a hoot. It's a tortoise life for me. And here's what he says. If walking is good for your health, the postman would be immortal. Okay. A whale swims all day, only eats fish, drinks water, and is fat. Okay. A rabbit runs and hops and only lives 15 years. Okay. A tortoise doesn't run, does nothing, and yet it lives 450 years. And you tell me to go exercise? I don't think so. I'm retired. Go around me, okay? All right, welcome. Well, anyway, David Brogdon is here this morning, and his pretty wife, Sonia, and his beautiful daughter, Emily, are here. Emily's looking for a job in communications. If any of you have any openings, she's looking. We try to get the best people in the best jobs, so she'll do well. So if you know of anything, let us know. Anyway, David and I have been good friends. He's a cohort in the evil of playing golf with me, and I've actually played with golf clubs that he has helped my wife buy for me or has given me or something of that nature. So anyway, we're glad to have David. David is a local attorney, has his own law firm, and his call to fame is that Jim and Joanne's daughter-in-law works for David and keeps him on track, I'm sure. Okay, anyway, we're glad to have David, and he's going to talk about wills and estates, and there's a little handout that he's given that you can take notes on. We didn't have enough. Take one down, Stan, and can you, and make some more. How many do you need? How many did not get a handout? All right, about 10 or 12 more. Thanks. They'll be upcoming from the basement shortly. Anyway, we're glad to have David with us, and he's going to share some things about wills and estates and those things, and also if you have questions, he'll have a little time for questions, and I'm going to keep the mic open with me so that I'll pop in every once in a while and make a comment and ask him a question and ask him what his score in golf was the last time he played or something like this. But anyway, we're glad you're here. And next Sunday for our class, Brian Reagan is going to be here, and he's going to talk about some things like medical directives and those things. And if you've been keeping up with some of the going-ons of the little 13-year-old girl, Jahai, in California, you know that that's a very important question about when can we do those things. And then the fourth Sunday of the month, we're going to talk about caregivers' rights and also things like when can we pull plugs on our relatives, things like that. Oh, easy things. Somebody says, why are you talking about aging? Well, because we need to talk about it. That's why. Let's pray. Father, we're thankful for the day, the beauty of the day. We're thankful that we've just gotten a beautiful weekend, and we're thankful that we can be here today and to sit at the feet of David and just learn some things that will help us to make our plans, help us to listen carefully and attentively, and take from David the things that will help us in our families, in our homes, and in our communities. Thank you for your love for us that brings us together on this first day of the week, and help us to honor you and honor Jesus as we meet together today. We pray in the name of Christ. Amen. David?
Marcus, I think it's on now.
By the way, I'll interrupt him already. We are videoing these presentations, and I think we have, did we get the one on, where did Matthew go? From last week, it's on our website, and what David presents today will also be on our website. So that's why we're hooking him up to this, and we've got a video camera back there. So.
Well, now knowing it's on the website, I need to make the caveat that this is marginal legal advice. It's not to be used for any other purposes other than entertainment. But I appreciate so many people I got to see out in the lobby that I haven't seen in years, or I may have seen lately, but it was a really good opportunity to see you guys again. Outline that you have is just kind of a guide for me to kind of stay on track if I get off on a tangent. And the area of wills and estates, and I think the aging gracefully, and I talked to Elizabeth, she came by the office the other day, and it was funny. She says she's young and she didn't know if she needed to age gracefully, but some of what we'll talk about will apply to even some of the young, and not necessarily a will. And I don't want to necessarily get a show of hands, but if we had a group of lawyers in the room, I would dare say, if we asked the lawyers to raise their hand and say who has a will or who doesn't, the ones that have a will, the hands would be very few. Isn't that funny? People that are in the practice, So it's like I grew up near Memphis. Excuse me. I'd never been to visit Graceland until we decided to take our kids on a trip to Graceland a few years ago. Now they loved it and wanted to decorate their rooms just like Elvis's house, but when you have it available to you, sometimes you don't take advantage of what you could do or should do, go visit places or go get a will done. But lawyers, by nature, I think, are procrastinators, so you're going to find lawyers that will not have wills. What I find in my practice, kind of going back, I started out in the insurance business in 1986, went to law school at night. I've testified in courts across the state as an insurance expert. Probably half a dozen times I've testified from one end of the state to the other as an expert. People ask me what my forte is. It must be insurance. Well, I was talking to Jerry Smith, another attorney in town. We were talking about the testimony in court. He said, well, you've testified for me 3 or 4 times on probate matters. And I've sat as judge for Judge Jackson on occasion. So when I look at it, I probably had as much expertise in the probate as I have the insurance, but I never think of myself as knowing it. Part of the reason we have problems with probate is probate, for the most part, or estate planning, has always been a moving target. And when people come in our office, it's amazing. Whatever the reason they come in our office, they've always been told by a friend or a colleague or whatever, this is what the law is. And it's not necessarily the way it is. And I put down on the outline the information age. In our information age, if you want to know anything about trust, you want to know anything about wills, you want to know anything about powers of attorney, with Google, Bing, Yahoo, those type of things, you can find out anything. Now, the problem is not everything that you find on the internet is actually correct. There's a commercial where it's like, I think it's a State Farm commercial where the guy asked the girl where she heard that. Well, I heard it on the internet. They can't put anything on the internet that's not true. Well, it happens all the time. And people have misconceptions and so forth about what they can do and they can't do. Many people come in the office and say, well, if we as husband and wife do a will together and then the spouse dies, I can never change my will. Now, that was actually the law years and years ago. And an older attorney in town a few months ago came by my office and said, I've met with a client that the mother was told that it's no longer a contractual will. When did that change? Now, he's an older lawyer, and he's many of you probably know him, but he didn't know that the law had changed back in 1985. And it kind of reminds me of Robert Littleton. When I first went into practice, went in with Jerry Smith and Robert Littleton, Robert said it was really more fun years ago when you could practice law and you could do it by ambush. But when they came up with these new rules of civil procedure, where you had to inform the other side everything you had on your case, and the other side had to tell you what they had on the other case, it was no longer trial by ambush. And I said, the new rules of civil procedure, what are you talking about? He said, well, they came into place in 1977. So some of you think that would be new too, but for some of us, we were barely, I was out of diapers in 77. So. But anyway, planning or not planning, on the outline, no planning whatsoever. What happens if you don't plan? That may be the reason a lot of lawyers procrastinate about preparing wills. The statutes in most states, especially in the state of Tennessee, pretty much outlines how your property, your things are going to be distributed. Generally, if you're married, a husband and wife, most of what you have is jointly owned. Bank accounts, usually jointly owned. Real estate, unless you specifically make a notation for it not to be jointly owned, it defaults as tenants by the entirety. So if Sonia and I were to go buy a piece of property tomorrow and we never designate that we're husband and wife, by law, it's going to default as property owned by husband and wife. What that means is, should one of the spouses die, the other spouse automatically gets that property regardless. Now, we see a lot of cases where people, for some reason or the other, will specifically ask that the real estate be placed as not by tenants in entirety, joint ownership with no right of survivorship. That means that the spouse dies, the other spouse has their interest, but the spouse that died, if they had a will, they could have willed their portion of that real estate to anybody they wanted to, whether it was their wife or their kids or their friend. It's very unusual, but that happens. For the most part in society, when you buy property, real estate, one spouse dies, the property automatically goes to the other spouse. When you have children, and generally whether it's minor children or adult children, and there is property that is owned directly by the individual. Let's say Dr. Hinkle has property that's owned only by himself, and he passes away. That property that's only in his name can be, without a will, can be distributed to his wife and his children, all in equal shares, because the spouse is entitled to a child share. So it's almost as if the spouse is the child. That may not have been his wishes that she gets the same share or lesser share than the children, but if he owns property that's only in his name, that's the way the law, the statute allows it to be distributed. For the most part, if you don't have a will, that's the way it will pass by. When you have blended families and so forth, it complicates things a little bit. Non-blood related children without a will may not be considered in the way the statute allows things to be distributed. So that may be a reason you need to have some paperwork or planning. But again, a lot of lawyers do not do wills because they are very familiar with the distribution based on statute. So they say, why do it? One big advantage, even if you want your property to be distributed exactly the way the statute would have it done, is a money-saving concept. If you do a simple will, I don't care if it's a one-page will, and you put some magic words in it like no bond for the executor. that can save your estate a significant amount of money depending on the value. Our probate court, I think most all the probate courts require, when there's not that magic wording in there, that there be a bond posted. And that's usually, the bond has to be 1.5 times the value of the estate. It means you've got to go down to Morrison, Fuson, Dixon Insurance, somewhere, and obtain a bond, which will cost you roughly about $750 for a minimum bond. That's a lot of money. A lot of people with no bond, especially if the value of the estate is not very high. So that's one of the negative aspects of not having a will. The aspect of the blended family is another. It may not be distributed. No planning on outline during incapacity. And this whole outline is getting a lot of room if you want to take some notes here. This one that bothers me the most, and the one we see more than anything else, is not planning for an incapacity. Elizabeth and Jeff are young. My daughter's young. I see several young people in the audience today, and you think you're absolutely invincible. You're healthy. Everything seems to be going just absolutely right with you. But you know, there are people that have accidents or strokes, even at young ages, and they lose their mental capacity to be able to handle their affairs. And if you don't have something in place for someone else to take care of those affairs, guess what happens? There's no other resource except for conservatorship there's a mechanism to take care of you and your stuff. Whether it's your house and you need to use monies to pay for the bills that are related to the house, there's no way of paying those unless you have certain things in place. Some people have put people as co-signers on bank accounts that allows them to pay some of the bills. That's one help, and that's more of a planning nature. You put them on as a co-signer or an additional or joint owner on the bank account. That's some planning. But if you have no planning, nobody can write a check. Nobody can make certain calls about selling property if you need to sell property for your incapacity. And the conservatorship, and I'm throwing these things out to you as cost, and it's alarming to some people because the minimum cost to do a conservatorship, and this is probably if you can get attorneys to volunteer some of their time, you're looking at a minimum to set up a conservatorship of about $1,500 minimum. And I see cases that would absolutely shock you at how much money is taken out, because a conservatorship requires someone hiring an attorney to file the petition in court. There has to be a guardian ad litem appointed, meaning someone usually in the legal society who is appointed by the court then to go meet the person who's incapacitated. They have to report back to the court whether the person is incapacitated, and is the person seeking the conservatorship competent and going to look out for this person's best interest. That guardian ad litem, usually the attorneys are going to charge $200 an hour to do that work, and depending on how much time they've got, you could have $1,500 easily in the guardian ad litem, not counting whatever the attorney's fees, the court cost, and you have to do an annual accounting. Plus, you have to continue every year to have a doctor review the person's capacities to see if they're still unable to perform their duties. Many of you may know Alan and Pam Jones. Pam Jones was, I think she worked at Burns School years ago, and when they were building 840, there was an accident involving an 18-wheeler. The lady that was with Miss Jones, Miss Cavender, passed away, and Miss Pam Jones had only been married to her husband 6 months, and she's still sitting over there in the nursing home. I ran into Alan a week ago, and he said he still goes over there, and she can utter some sounds, but she can't communicate with him. And this, I think he said it's been 13 years ago. She had no power of attorney, nothing in place. They had just been married 6 months. He's been there. It's amazing. It's just a sad story. He goes and he still has hope that she will be able to regain some of her physical and mental capacities. And they stopped the therapy on her ankles and legs and so forth. And every day As long as I've known him, he goes to the nursing home and he moves her ankles and moves her knees and so forth with the hope that someday she can get back. It's been 13 years since it hasn't changed. We had to go to the court for a conservatorship, get it all started. Now there was monies available because there was an accident and there was a truck that was at fault. So there was some money, but all that money in 13 years to take care of her has been used up. But still, as of this day, once a year, we have to have her doctor evaluate her, give a report so we can go back to the court that she remains on the conservatorship. The court's monitoring and make sure any Social Security monies or anything that comes in for her benefit are properly handled, even though it's her husband handling it. That's an example of no planning, and it could have been solved with a simple power of attorney. You know, most attorneys can get you in with a will and a power of attorney and anywhere from $150 to $250 for the most part for those simple documents. If trust or lengthy wills or whatever, sometimes it's longer, but just think about it. All the money that's been spent on the conservatorship process in that example, when if they had a power of attorney. They didn't think about it. They just got married. They wanted to start their life and looking forward, had no idea something like that would happen. Even during healthy times, and we don't have any planning, there's certain things that could happen. You may be called out of town and so forth. We have many times where people in the military are going off. The military does a really good job of setting people aside and preparing power of attorneys and so forth to handle business affairs while they're out. But we still have quite a few where people are going out of town, out of the country and so forth, and so we need a power of attorney just in case. And that's healthy times, but there are times when you can't be around. And there are certain things such as limited power of attorneys to allow certain functions to be done while you're gone.
David, let me interject something here. When our kids leave our grandkids with us, they always sign a paper that says, I have power of attorney for medical needs and whatever happens. And also for younger families, if something happens to mom and dad, who gets the kids? That's a very important question.
That is a good question, and there's some misnomers too, because I don't know how many times people come in the office and say, when I die, I want to will my children to so-and-so. You laugh. I hear it very often, and especially when there's divorce situations involved. I do not want them to get these kids. I want to be able to will, my rights when I die to my children. Well, children are not stuff. Okay, I remember a teacher in school said never use the word things and stuff when you're trying to describe things, but you know what I mean when I say stuff. It's your stuff. Kids are not stuff. You can't will your kids away. What the probate court will look at should something like that happen is if you put it in your will about your children and what you would like to happen to your children or the people to care for your children and this, that, and the other, it is something the court takes into consideration, but it's not absolute. It's not absolute at all. As a grandparent, if something will happen to one of your children, you've got minor children, you have, in my opinion, would have an obligation to be proactive and get to the court and say, we want to take these children, we want to be the guardian of these children and so forth. Be proactive. Because any blood relative, grandparents especially, if both mom and dad were killed in a common disaster, they have equal standing with the court, and the court has to make a decision as to where they're going if there's competing interest. Dr. Hinkle, his wife may say, we need to take care, or you could have brother and sister-in-law, or daughter and son. In your case, let's say Mary Beth and Joe decide that we want to take in your grandkids from something like that.
In the case of older grandparents like us and younger kids, our kids always designate somebody else to take care of the kids, the siblings. But the point I wanted to make about, like, if your grandkids are left with you, and your son and daughter-in-law are on a trip for a week.
Right.
If they get sick and you take them to the hospital, the doctor can't treat them without the papers. So you got to have, number one, the insurance card, and number two, you have to have that little paper that says, I give James and Harriet Hinkle the right to give medical directives to the doctors.
You're right, and a little caveat on that one as well, and my wife's in here, and she'll probably slap my hand when I say this, but not every hospital will agree to accept that document. Just like I may leave these out front or something if you want to scan some examples of some durable power of attorney and healthcare power of attorneys. I don't know how many times I've had people that we have prepared power of attorneys for health care for who have gone to a hospital that's not here in the local area, and they get a call from the hospital saying, there's a power of attorney, but it doesn't look like the one we usually see. We're not, we don't want to use it. And they want some type of advice or some type of letter from our office saying it is a valid power of attorney for health care that somebody can use. So what you're doing is exactly the right thing to do. When they give you a power of attorney to go ahead and take it, give the insurance cards and so forth, the child needs some care. More than likely the hospitals are going to take care of them. But don't think it's always foolproof, because there could be a situation where the hospital says, this is not something we're familiar with, we're not willing to do it. And,
should we, when we travel with that document, a copy of that document?
the healthcare power of attorney? Is it? I generally would say no, because as long as someone in your family knows how to get their hands on it, if that needed to be faxed, scanned, or emailed, at a location where you were, for instance, if you're traveling to Hawaii and you get out there and your power of attorney for health care designates your husband or your son and so forth, that could be faxed out to you. It wouldn't necessarily hurt if you had it. You can make a copy of it, but always keep the original where it will always be the safe place. And that kind of, you guys probably know, you've heard this before, but in our office, Jerry Smith years ago told me when we were doing wills, our office never keeps a copy that has been signed, notarized, witnessed of the will that you do in our office. And I always thought, that's unusual. Why wouldn't you keep one? You need to know. We always put a note in the file that the people were here, they signed it the day they signed it. And the reason when you mentioned about keeping copies, I'm very, very leery about making lots of copies and spreading those around. And the reason being is the original will that you sign is the will, and the law says that is the will, because the power of attorney as well. Power of attorney says on it that a valid copy is sufficient, but the wills do not say that. What happens is the probate court will accept a copy of a will if the people that bring a copy of the will come in and swear under oath that we have made a diligent search for the original, we could not find the original, and all we could find is the copy. So the probate court can accept that copy. Now, as an attorney, I have an attorney-client privilege with anyone that comes into my office. That means I cannot do anything that's going to do a detriment to what your wills and wishes are for anything, whether it's on an insurance claim, a probate case, or whatever. Wouldn't you say that my attorney-client privilege with you extends even after death? Would you not agree? So if you leave my office and you decide to change your will, revoke the will, whatever, there's several things you can do. You can rip the will up. That's a legal revocation of your will. You can write revoked across your will. That's a revocation of your will. Or you could write a new will. All those things in our state are revocations of your will. Think about the things that happen when somebody dies. There's multiple children and whatever, and the kids don't get along. One child has a copy of the will that gave everything to that child, but realizes that mom or dad had just given everything to another brother or sister. He finds the original will in a drawer at the house that's later in date, which is the current one, which means the copy that this boy has is a revoked will. Guess what happens to that original will that he found? Not all the time, but it's ripped up, burned, whatever. It doesn't exist. So they've made a diligent search. Now he signs an affidavit that's not true, but what's presented to the court is a will. I'm not a fan of making copies and distributing them out even to your family members. But we don't keep one in our office because I don't want a family member coming up to, now didn't your office do a will for my mom? Yes, we did. We don't have a signed copy here. And that's the reason. We had just before Christmas, a man and his son, it was a stepson, and they had come in and they were desperate to come to our office that we about 10 years ago had done a will for his mother. And his mother had property all across the state of Tennessee and was going to, the last thing that she said when she was in the hospital, I had been to my lawyer's office a week or so ago and changed my will. I'm writing my daughter out of the will. Completely wrote her out. Well, they came directly to my office because they knew all the legal work they'd had done was at our office. We didn't meet with her. The husband said, I know she did. She left. She was gone all day, and she said she was going to the lawyer's office. We never talked with her. We had no note whatsoever she'd ever called our office and whatever. We don't know what happened. I called around to several lawyers in town that I knew that did wills, and they didn't know anything about it either. There is no clearinghouse for wills, by the way. I mean, on insurance, if you have an accident and you want to know if the person that hit you had insurance, you wait about 30 days, and by law you have to turn in the form if you had an accident that you've been in a car accident. The state of Tennessee has a clearinghouse. I can find out whether you have insurance or not because you would have had to turn that information in. There's no such clearinghouse on something that depending on your estate. We have cases in Nashville and Williamson County that are multi-million-dollar estates, and there's no clearinghouse to find out where the wills are. Some people file their wills with the Register of Deeds office, so you can find a will up there, but that may not be the most accurate and the most current. So there's always problems and pitfalls there. But again, if I could stress anything, when you get a will made, don't make multiple copies and decide you're going to distribute them out. Put them in a good safe place, a safety deposit box, something that your heirs can get into for the purpose of searching for a will, and have that one original there.
It is important that if you have a safe deposit box where you keep your wills, that you have somebody other than just the two of you who are on that, that they can go in and look at that will. Otherwise, they have to get a court document to open it.
With one exception, and maybe in other counties, in our county and in surrounding counties, and Elizabeth worked at the bank for a while, so she may be able to give us some information there as well. But generally what we find is they will allow you to enter that safety deposit box for one purpose only, and it's to determine if there's a will in the safety deposit box. But like you said, the safer way to make sure somebody can get in there, because again, banks have people that work there, and people have opinions about what they will and will not do. It's I have people call all the time and say, well, you get arrested in Burns if you do this, this, and this on the streets in Burns. Well, the first question is, who's working when you're planning on doing that? Because it's the personalities of the officers that come into play more than anything else. And,
may I say something?
Sure.
In many of the states, and in the banks, financial institutions, first thing they're going to want to know, they look around to see if there's an IRS agent, because he can seal that and you cannot get in there.
That's right.
So you need something other than just a safe. Well, you need a safekeeping, but it does not need to be in a bank safe deposit box.
That may be a good point. Very well good.
Because the IRS can seal that thing, and you never know who an IRS agent is. You may be working with him every day and not know it. And I wear the same hat you wear, and that's the reason I'm speaking.
Right. Right. Well, in IRS...
I'm in the financial industry, too.
Well, since you mentioned that, something I was going to let everybody know, something that comes up all the time about distributing property and taxes always come up. Right now, we don't have a federal death tax, or inheritance tax, whatever you want to call it. State of Tennessee it will basically not have one in 2016. Now, for most of us, it really won't matter anyway. Dr. Hinkle it probably affects him a little bit, but to 2012, if you got an estate of a million, over $1 million, it could be taxable. It goes up to $5 million in 2015. So for most people that I hang around with, I don't think we're going to have any problem with having a state inheritance tax anyway. But it can. You could have somebody that makes $50,000 a year, have a house paid for and so forth. And how can you get an estate? You look at that with $50,000 a year. You got their house paid for. They live pretty modestly. How can they possibly have a $10 million estate? Any idea how they might have an estate that way?
They can have 401k plan.
They could have 401k plan, and kind of in that same line.
Almost anything, it'd be evaluated to that level.
What if they had a life insurance policy payable to the estate? Most people put a beneficiary, but I don't know how many times I've had people come in the office and they said, I don't have a problem with the beneficiary, I have it payable to the estate. We don't know what, as I said before, estate planning is a moving target. Taxes and issues related to taxes have changed since before I became a lawyer all the way to date. We used to have lower inheritance taxes, both federal and state. Now it's about to be abolished altogether. I don't know what's going to happen in the future. If I do a will for younger people today, 10 years from now, we may have different taxes that apply to it. I don't know. But what I've always told people is never, ever have your life insurance policy payable to the estate. Always have a beneficiary or a contingent beneficiary that you hope will be there.
If a 401, this is tax that was brought up, if a 401k or an IRA, if you have beneficiaries for the IRA, it does not have to go through the estate.
Right.
Is that correct?
That's correct. That's correct. And that's another way to try to avoid probate. The internet, TV talks about avoid probate. And I forget, it might have been Cindy that told me to mention this today, that people generally think that when they have a will, they don't have to go to probate. Well, the will is the document that gets you to probate. It's not avoiding probate whatsoever. The will is what directs the probate court to distribute the property as you wish it to be distributed. There are some ways to avoid probate, 401ks with beneficiaries.
And if you have property, for instance, if you have a farm of 40 acres or something, mm-hmm. If you do not go through probate to get that taken care of, then if your son wants to sell that property, he has to sell it for what it was bought for 30 years ago instead of what it came through probate. So there is a reason to go through probate.
So there is, because if you go the basis of the property, the basis value of the property and the increase. However, with inheritance, because we're unlimited now, you don't have to worry about that on those taxes. Now, one thing with real estate, if one of you came in and had a spouse that passed away, or a mother or father has passed away, and you said, all the bank accounts were jointly owned between me and Mom. Mom's the only survivor of the family. All of the bank accounts were jointly owned. The CDs that Mom owned were payable on death. Anything that was life insurance, 401ks, anything else had a beneficiary or a payable on death as well. The car, Mom had already transferred the car to your name. The only thing we have is the house that's still in Mom and Dad's name. And they said, we need to probate the estate. And I said, you may not have to probate the estate at all. And I want you to keep in mind those things when you have family members and yourself involved in it. Think about joint accounts, not co-signers on accounts. Because even with a power of attorney, if you don't have a co-signer, you've got a power of attorney. The power of attorney ceases the moment the person passes away. And there could be a bank account that's just in Dr. Hinkle's name, and there's $5,000 in the account, And Ms. Hinkle comes in and says, how can I get this account? How can I get this money out of the account? Well, without probate, you can't, because she wasn't placed as the joint owner of that account. That comes up so often. Look at those type of things. Make sure that CDs and all those things are payable on death. Do anything you can to avoid it going into probate, and you may not have to go into probate. But the real estate, this is a kind of a misnomer. By law in Tennessee, and a good portion of other states, real estate transfers to a person the minute death occurs. So if my parents pass away together tonight, the minute they take their last breath, my brothers and I have inherited their real estate without ever going to court whatsoever. Now, my father's will may direct the real estate to be different, but if there's no will that's probated whatsoever, it automatically vests as a right to those survivors. Okay, now what the problem is, and why people do have to probate if there is only real estate, is if someone wants to buy that real estate. And we're talking about more than just cash money. If I've got cash and I want to buy the property, Dr. Hinkle's property, I don't have to get title searches done, then I don't have to get it probated. But most banks use title insurance companies, and title insurance companies will not write title insurance on real estate that has been passed that way to my brothers and I until we have owned it or it's been vested to us for 2 years, or it's been probated. So it's not anything under the law. By law, it belongs to us, absolutely, without regard to anything. But title insurance companies won't loan the money if it's not probated or you've owned it that way for 2 years. So was that the okay. On this, I put some verses on it, some problematic things in the Old Testament. Everyone knows about the Esau and Isaac and the story, and the fraud of how they got Dad to basically give the birthright to the other. And when you think that's Old Testament, those things happen today. I mean, it's amazing how many things like that happen. The times I've testified in court, it has been about visiting with the person that's going to be. I've been a witness to a will, and I have to describe what was there. We don't allow somebody to take from the will. For instance, if the Graves were at our office going to do a will, we would not let anybody listed in their will. They couldn't be in the same room with them because undue influence. We usually don't like a family member to bring an older family member to this law. We made the appointment so they can come see you, whatever, because you don't know what kind of undue influence that. If you want a will contest, let that happen, because if anybody wants to challenge it, that's a good reason to challenge it. So.
Let's talk about mirror wills.
Oh, and that was kind of the contractual wills. Real quick example. We had a case years ago, Jerry Smith and I, with a lady who had a lot of Coca-Cola stock. She was worth a fortune. She's from Dixon, and her husband took her to an attorney down in Chattanooga, and they had mirror image wills. And when they were there, it was, as I mentioned a while ago, about contractual wills. Husband, wife, mirror image wills. Everything goes this way, if this one dies. And in the wording of the wills, it said that should one spouse die, the other spouse could not change their will. That's no longer the case. You can have mirror image wills today. The minute one spouse passes away, you can run into the law office and you can change it however you want to change it. There is no requirement that you can have every handshake or hug or kiss or whatever you want to agree that this is the way we're going to do it. Should I pass away, and you're going to follow up with it as well, but that's no longer the way it is. So if once one spouse passes away and they want to change every term, they have the right to do so.
We're going to have him come back, I think. We need about 4 hours on this, Dave. Thank you very much. maybe we'll get Brian to mention this next time, but Tommy talked about final disposition, a will that is final disposition, or a power of attorney that's final disposition. And he said because of a lot of the fractured families now, people were adding an addendum to their power of attorney that said this person has the power of attorney after the person dies to take care of the final thing. And maybe we'll have a little time for that.
Just briefly on that, on your health care power of attorney, that is the power of attorney that does survive. The wording that Tommy Marvin's talked about is in most of the health care power of attorneys, that it allows, that's part of the health care, disposing of bodies and so forth. So it's put in the health care power of attorney so that your loved one can make those decisions and so forth. But that's the only one that can survive.
And Brian will probably talk to that next week. David said he had some copies of powers of attorney and some other things. If you want to take a look at some of those things, we'll just leave them here on the front, and you can come by after worship this morning or after Sunday school and do that. Thank you, David, for coming, and thank you for being here. And I know you have lots of additional questions, and hopefully we'll answer some of those next week. If not, we'll have to bring David back again. So thank you, David and Sonia and Emily, for being with us today. God bless.